Hello, and welcome to the Elder Law and Guardianship Training video series for attorneys. This video series explores the legal side of guardianship of adults in Pennsylvania. Whether you are an attorney working in guardianship and capacity hearings, a judge presiding over such hearings, or another professional working with older Pennsylvanians, we hope that you will find this video series informative and beneficial. This welcome video orients attorneys to the world of guardianship hearings and explores the preparation needed for capacity hearings. Additional videos in this series will address client relationships, zealous advocacy, alternatives to guardianship, limited guardianships, emergency guardianships, the use of a guardian ad litem, review hearings, and post-adjudication responsibilities. Now let's begin by observing the fictional law office of Miller, Jordan, and Wise, as attorney Avery Green is meeting with the firm's partner, Charlie Jordan, today to interview for a job as guardianship-focused counsel. Let's see if Mr. Green can impress Ms. Jordan enough to get the job.
Nice educational resume.
Thank you, Miss Jordan.
You can call me Charlie, Mr. Green.
If you'll call me Avery.
It's a deal. I'll be direct, Avery. You have a pretty comfortable situation working in healthcare law. That's a desirable position and not the kind of job most people choose to leave. Where does this interest in elder law come from?
Thank you for asking. My uncle was a lawyer. He's pretty much the reason I went to law school. He's also 76 now. He was diagnosed with dementia over a year ago. The 2 years before that were interesting, to say the least. My mother and I have been his primary caretakers for some time now. There was a major incident with him wandering off into the street during the holidays last year, and the police found him in a snowbank.
And you were worried he might ultimately be placed under guardianship.
Yes. The more I looked into it, the more uncomfortable I was. He's still very lucid most of the time, and he's brilliant. He lives with my mother now.
How did things end up?
Luckily, my uncle planned ahead and gave my mother power of attorney several years ago. I'm helping her stay on top of his finances, and she had an anti-elopement system installed at her house. It's pretty obvious when he's lucid and when he isn't. We're lucky that way. He's lucky my mother was a nurse, too. Most of the time, he's fully involved in the decision-making, and when he can't be, he's not been stubborn or confused at all. He just gets a little sad and lets us make the decision. I think we're lucky that way, too. It's never really an argument.
It sounds like he's lucky too.
I've got a lot to learn, but I'm definitely doing my research already. When I noticed you were looking to hire an elder law attorney for guardianship proceedings, I was immediately interested.
Because you know that alternatives to guardianship exist and should always be considered.
Yes. I am not an expert on alternatives, but I am learning.
Power of attorney is a good one. Tell me, do you see a situation where guardianship could be useful?
Yes, I do. If we weren't around to help, I'd hope my uncle would be well taken care of. Guardians serve an extremely important role.
Do you see yet how your healthcare law background could be helpful to you in elder law?
I do, and I'm interested to learn more.
As am I.
As you probably guessed, Avery got the job. These attorney characters will provide us with a fictional window into the world of elder law attorneys navigating guardianship proceedings. We will learn from both Charlie's seasoned perspective as well as Avery's learning and onboarding process at Miller, Jordan, and Wise. Additionally, we will hear from real experts working in guardianship in Pennsylvania along the way. Let's shift focus now to some of those experts.
First, what I would do is suggest that they seek out more experienced attorneys for advice. There's nothing like talking to a colleague to let them, tell you what they should expect when they come into the courtroom, what they should expect before they come into the courtroom, how much they should devote time to each case, don't hesitate to reach out to an orphans court judge and actually speak to the orphans court judge too, because county by county, each judge has their own likes and dislikes. Expectations are different. Obviously, we strive for uniformity, but at the end of the day, figure out what could be the most effective way to represent your clients, in the courtroom.
Create an attorney-client relationship with your client that's as natural and typical as any other attorney-client relationship. You really need to get to know your client and get to know what their wishes are and to treat them with respect and advocate for respect for them and for their dignity.
Shortly after graduating from law school and passing the bar, I was given a case. An individual had a serious car accident, and that led to a traumatic brain injury. And as a young lawyer, to sit with parents who were now facing incredible challenges, and it was quite emotional and difficult for them to process what they were going to have to do for their adult child. And to see their reaction to the fact that they were seeing me because they needed to now secure guardianship for their child. It was a very, very emotional time for them. And what I've tried to always remember is that this is not anticipated. This is not normal. It's a very trying and difficult time. They're dealing with a lot of things, principally caring for their loved one. And to suggest now that you have to talk about these things in a forum, even if it's in a closed hearing though, to many people, that merely adds to the stress. And how is it that we can make it less stressful?
One that has always stuck with me, I had an older gentleman who had worked his whole career, had served in the military, had gone to work when he was 16, a very dignified fellow, and his nephew was exploiting him and taking his Social Security checks and his pension checks, kept him in an apartment where he wasn't being fed, he wasn't being having all of his needs attended to. He was really living in squalor, unfortunately. And in that case, a guardianship and the intervention of protective services was vital to, his survival. And we felt that the court, in collaboration with other partners, made a difference in that gentleman's life.
An early experience for me was realizing that guardianship doesn't necessarily wait for older age. There are younger people who may also need guardianship, and it's never too early to start preparing because life is uncertain. It's something that nobody wants to think about, but it's important to plan in advance. Alternatives to guardianship are for everybody. Some of the best advice I received is to take time to listen and learn from clients. Even though clients come into a client meeting looking for you to give them legal advice, oftentimes you receive a lot of wisdom from clients if you take the time to listen to their stories, to build relationships of trust. Because even though the client may leave the office that day and you may not see them again, the documents that you create are going to affect their lives. And so knowing that it's grounded on a relationship of trust and mutual respect carries through.
We've explored some of the fundamental aspects of guardianship, and our next topic is capacity hearings. The Pennsylvania Guardianship Handbook, which is available from the Office of Elder Justice in the Courts, states, a guardianship court order allows a designated individual, individuals, or entity to act on another person's behalf when they are determined by a court to be incapacitated. An adult who is partially or totally unable to receive or understand information or communicate decisions effectively to the extent that they are unable to manage their finances or meet their own safety and health needs is considered incapacitated under Pennsylvania law. For a person to be adjudicated incapacitated, they must meet certain criteria, including being 18 years old or older and unable to understand and evaluate information or make and communicate decisions. The court can declare a person totally incapacitated or incapacitated in limited areas, such as making decisions about their property and money or personal care. The court's decision needs to be based on a medical, psychological, or other expert evaluation, as well as other evidence of the individual's inability to make decisions. According to the American Bar Association's guide, Defense Against Guardianship, in order to represent individuals responsibly, attorneys must determine if their client has the capacity to engage their services by asking direct questions relevant to the determination of capacity within an upcoming hearing. The questions include, what do you need help with? Why do you need help? Do you want me to help? How are you hoping I can help? And others. Straightforward questions in an effort to determine a complex scenario, one that is unique to each client. Additional tips for communicating with clients with special needs include: focus on the person, not the disability. Try not to enter a client relationship with preconceptions about the client's needs. Let them make their needs clear. Do not assume that a person with a disability needs assistance or is more fragile than others. Do not assume they cannot hear you. Do not assume they cannot answer your questions. Respect a person's right to indicate the type of help they need, and do not be offended if they do not accept your offer to help. There are, of course, many more. We're now going to shift to a discussion between Charlie and Avery about preparing for capacity hearings. They are going to discuss Rule 114. Rule 114, client with diminished capacity. When a client's capacity to make adequately considered decisions in connection with a representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client and, in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6. When taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. This rule is very important in shaping how guardianship matters proceed in Pennsylvania. Let's see how Charlie advises Avery to handle these important, yet often nuanced and challenging preparations.
Let's talk about capacity hearings. How will you prepare?
I was able to review Rule 1.14, client with diminished capacity, like you asked me to.
Good. What stands out?
I wrote, maintain a normal client-lawyer relationship, take reasonably necessary protective action, and client information remains protected from disclosure except in particular circumstances.
Good. Reasonably necessary protective action is a big one, and one I wanted to discuss today. First off, don't conflate protective action with guardianship. There are a wide range of situations where protective action might be needed, but a guardianship would not be, as suggested in Rule 1.14. Additionally, lack of capacity does not necessarily indicate a need for guardianship. You know this, but it bears repeating in the context of this rule. Guardianship isn't always needed. Less restrictive alternatives to guardianship must always be explored. Also, protective action and its interaction with client confidentiality requirements are inherently complex. It is important to remember that client confidences are protected. You cannot reveal them except when you determine that the client has diminished capacity, the client is at substantial risk of harm, and that revealing information is reasonably necessary to protect the client. I say all this to give you some pause and caution you about protective action. We must always keep those points in mind. That said, could a guardianship potentially be a reasonably necessary protective action?
If the client lacked the capacity to make either financial decisions, healthcare-related decisions, or both for themselves, then potentially yes. But the attorney should be advocating for less restrictive alternatives wherever possible.
There are times when guardianship is an effective solution. Our job, though, is to defend our clients' rights, advocate for their wishes, and, as required in Act 61 of 2023, explore and document all least restrictive alternatives possible.
A lot of what I'm hearing you say as you're onboarding me here comes back to pragmatic and compassionate points. Treat alleged incapacitated clients like any other client. Maintain a normal relationship with the client. Keep client confidences. Try always to take client direction to the extent possible, even if I disagree with it. Allow the client to set the goals of the case.
I personally see pragmatism and compassion as two of the most useful traits with which to engage in this work. So I'm glad that's coming through to you. And how is a judge ultimately going to determine the extent of the client's capacity?
That would depend on the judge's findings of fact after presentation of all evidence, including expert witness testimony, which includes that of a medical professional who has evaluated my client's capacity and arguments of counsel.
So how are you going to determine for yourself ahead of time your client's, what again?
Desires and wishes.
Correct. How will you figure that out ahead of the hearing?
I will interview my client.
Just once?
Are multiple interviews necessary?
Are multiple interviews required? Perhaps not. Would I recommend it? Yes. Do I consider it best practice? Absolutely. Avery, I typically interview a client many times before I know how to best achieve their goals and properly advocate for the least restrictive solution. The Guardianship Bench Book advises that hearings be held within 45 days of the petition being filed, unless it's an emergency guardianship. In that roughly 6-week window, I've interviewed my clients as many as 4 or 5 times. Sometimes it takes fewer sessions than that, but it almost never is a one and done situation.
Really?
Yes. It is difficult to fully understand the capabilities and capacity of a client from only one meeting. Are you comfortable sharing personal details of people the first time you talk to them?
I guess I am not. Not fully.
We have to really listen to the client, and we have to let them talk. That means they have to get comfortable sharing information with us.
And that takes time.
And sometimes creativity, and potentially even some informality, and people skills.
I'm kind of shy. I worry about my people skills.
I know you're a little shy, but I don't worry about that, because you're kind.
Both Charlie and Avery referred to Act 61 of 2023, an important piece of legislation which has brought about significant and transformational reforms in Pennsylvania courts' approaches to guardianship. Specifically, Avery referenced this part of the legislation. Appointed counsel shall meet with the alleged incapacitated person as soon as reasonably possible after the appointment. Within 5 days of the meeting, appointed counsel shall file with the court a certification of the time and place that the meeting occurred. Another aspect of Act 61 they referenced requires that all less restrictive alternatives to guardianship be explored and documented. Act 61 also requires the court hold a review hearing within 1 year after a guardian is appointed for clients who show the possibility of regaining capacity, and for all alleged incapacitated persons to be represented by counsel. Charlie also referred to the Guardianship Bench Book. This resource was developed by Pennsylvania's Advisory Council on Elder Justice in the Courts and is available for free at pacourts.us. Guardianship in the courts is a uniquely nuanced and complex process, and learning best practices is essential to successfully protecting the rights and autonomy of alleged incapacitated persons age 18 and over. The Guardianship Bench Book has been recently revised and updated to reflect the latest changes with the passage and implementation of Act 61 of 2023. Now that we've let you know how to find the Guardianship Bench Book, let's return to Charlie and Avery's conversation on interacting with clients ahead of capacity hearings.
Ask them about their kids, their pets, their favorite hobbies. Ask getting to know you questions if you need to. If you actually connect with the clients in this process the way you would any person that you're meeting for the first time, then that's when they'll start to trust you. And then they'll share better information, such as what they actually want out of this process. Their wishes and desires should always be at the forefront of your representation and advocacy for them as their counsel. Knowing that the person's counsel is capable of advocating zealously for their client is also a priority of the courts.
So, if I want to really figure out their wishes and desires, I can't be Mr. Formal Lawyer the whole time. Maybe I show up to meet them in a polo instead of a suit and tie.
You're getting it. Keep your options open and make adjustments based on your client. Some clients will want your formal professional presence. Others will want you to be more relaxed so that they feel more comfortable. Try to read the room and figure it out for yourself. I once had a client who couldn't answer most of my questions. It wasn't until my third visit that I began to realize her issue might not have anything to do with her intellectual capacity. She was misunderstanding everything I was saying because she was having difficulty hearing me. I helped set up a hearing exam for her and found out she needed hearing aids. Using her resources, I was able to help her get the hearing aids, and she almost immediately began to answer my questions and make a lot more sense. Imagine if she'd been placed under guardianship and lost all of her rights and decision-making power when all this woman needed was a functional hearing aid.
Wow.
Say you go to an interview with a client and you introduce yourself and explain why you're there and what you hope to do. And they seem cognizant in everything you're telling them. You might assume the person had no capacity issues.
Sure.
But you go back a week later and they have no idea who you are.
I see.
Are you going to say, "Mrs. Johnson, you remember me. I'm Avery Green, your lawyer. We spoke last week"?
Maybe.
Not if you're representing our firm, you won't. You will introduce yourself again as though it were the first time you've done so. This can happen when you're working with clients who have memory issues.
So, part of maintaining a normal lawyer-client relationship is normalizing client communications in spite of noticeable capacity issues?
Exactly. Capacity is nuanced and complex, and client relationships are about respect. Never forget that your client is always deserving of dignity and respect. Highlighting your client's memory issues or other limitations isn't productive. They're doing their best. The last thing they need is you pointing out their struggles. They need you to be on their side as their advocate, and they need to know you have their back.
I can do that.
I'm sure you can. I wouldn't have hired you otherwise.
So when we have a client who comes in to see us at our estate planning clinic, one of the first things we have to do is assess whether they're able to understand what it is we're telling them and make legal decisions for themselves. So in assessing capacity, we're looking at how much the client understands in the conversation. And that usually just starts with getting to know the client, which is a great place to start, getting a feeling for who they are and their story and narrative of their life, because you can tell a lot from people just by talking to them. Once we've made the assessment that they understand what it is that they're there for, and we have an idea of what kind of legal documents that they want, and we're comfortable with their capacity, then we can go into creating documents that can help them protect themselves from guardianship in the future.
It made me really think seriously about other alternatives to guardianship for each of the individuals in front of me. It's also given me a chance to really reflect upon how much we should get to know each of the individuals. If you really don't know the individual's sort of life history story, what they're bringing into the courtroom, it's really going to be hard to say what they're going to need in the future, because everybody's life is different and unique. Everybody's life deserves, value or has value, and everyone's life should be then tried to maximize what they've experienced. If they were someone who enjoyed trips to a park, make sure they're getting to a park. If they like to read, make sure they get to read. If they like movies, get them to movies. If they liked a certain, hobby that maybe takes a little bit more support, can we do that or not? What are we trying to do to make sure that these individuals do not end up isolated? Because I think that's the biggest concern for most individuals is isolation. Frequently will lead to greater deterioration, loss of sense of community, maybe loss of sense of self, and all you're doing is then advancing all the things that have brought them into your courtroom.
Under Act 61 of 2023 in Pennsylvania, we now require counsel to be appointed for the alleged incapacitated person in all cases. That really makes a difference in the courtroom because as judges, we now have a balanced courtroom and we can hear more than one perspective, and we have the voice of the alleged incapacitated person present in that proceeding, making their wishes known and alerting the court to what might be going on from their point of view, which may be different from the petitioner's point of view. So that's made a huge difference. Act 61 also requires that the professional guardians be certified, and also requires that the court schedule review hearings more frequently. I've had a number of cases where counsel for the alleged incapacitated person made a real contribution to the process, but also to the individual they were serving. In many cases that I've seen, counsel has represented a person with intellectual disability who may not need a guardian, who needs to be sure that they have supports and assistance with their decision-making, perhaps supported decision-making, but counsel can really work with the family and other support providers to make sure those needs are being met without necessarily appointing a guardian. And we now have experience in Pennsylvania that where counsel have been appointed through a pilot project in Pennsylvania counties, the number of guardianships has been reduced by approximately 50%, the guardianships granted, because counsel have been able to identify alternatives to guardianship or less restrictive alternatives, or also limited guardianships that might be all that's needed to solve the problems in a specific case.
Thankfully, I've had counsel who have spent a lot of time, with their client and taken the time to fully understand the client's needs. And then they have taken the time to be able to come to the court and say, Judge, we're able to execute a power of attorney. They do not need a guardian. They have great family supports. We want to put it on the record who is here, who can help them. And you'll understand and see that there are plenty of people who are able to care for this person and help them as they go through the remainder of their life journey. And I've seen that with a few attorneys, and it's not just one exclusive case for me. It's nice to have a group of attorneys who really take the time to do that. Yeah.
As you can see, it takes diligence, time, relationship building, listening, and an unshakable sense of the humanity and fundamental rights of the client in order to truly and honorably litigate on behalf of their wishes and desires. We hope these scenes between Charlie and Avery and the perspectives from our experts have helped to show the fundamental approaches and mindset necessary to successfully represent clients alleged to have diminished capacity, and to appropriately and professionally argue for the client's stated goals and the protection of their statutory and constitutional rights in pursuit of the least restrictive solution that gives them the greatest autonomy and quality of life. This concludes the first video in this training series. The next 4 videos will explore client relationships, zealous advocacy, alternatives to guardianship, limited guardianships, emergency guardianships, the use of a guardian ad litem, review hearings, and post-adjudication responsibilities. We hope you will continue watching and learning. Thank you for listening and for helping to protect the rights of vulnerable Pennsylvanians.